Hello, and welcome to our session on direct marketing. My name is Nuria Pastor, and today I'm joined by Natalie Barnfield and Charlie Guile. This video is part of Phil Fisher's Get Data Protection Feed series. In previous modules of this series, you will have already covered the fundamentals of data protection law in Module 1, putting data protection into practice in Module 2, and cross-border issues in Module 3. We are now on to Module 4 of the series, What else is in the data protection landscape? In Session 1 of this module, you explore the topic of cookie law compliance, and today we're looking at Session 2, What are the rules on direct marketing in the EU? By the end of this session, you should be able to better explain the meaning of direct marketing, understand which laws primarily govern direct marketing in the EU, and recognize how you can lawfully carry out direct marketing activities. To start with, we'll look at what we actually mean by direct marketing. Direct marketing can be defined as the communication, by whatever means, of advertising or marketing material which is directed to a particular individual. This is the definition in the Data Protection Act 2018 in the UK. The definition in other EU data protection laws may vary slightly. Note that advertising or marketing material is wider than just material seeking to sell products and services. This concept also includes the promotion of aims and ideals, so it also covers material from non-profit organizations such as charities and political parties. Electronic messages such as text or emails will always be addressed to a particular recipient, so in practice, these forms of communications will always fall within the scope of being directed to particular individuals. Direct marketing does not include either genuine market research or routine customer service communications, such as an email informing a customer about delivery arrangements. However, if in reality these messages include promotional material more than just general branding, for instance, seeking to get the customer to buy additional products, the laws on direct marketing will still apply.
So now we're going to consider some of the laws governing direct marketing. And the first of those is the GDPR. Direct marketing would of course involve the processing of personal data. You'll likely be using someone's name, email address, or telephone number in order to carry out your direct marketing activities. And for that reason, you'll need to consider your GDPR obligations. So what are some of the key considerations or obligations under the GDPR in respect of direct marketing? Well, we've included them on the slide. So the first is transparency, or the obligation to provide information. Now, you may remember from earlier modules that the GDPR requires data controllers to provide data subjects or individuals with certain information about the ways in which they intend to use their personal data. So in the context of direct marketing, you'll need to ensure that your privacy policy or your privacy notice describes how you intend to use personal data for direct marketing purposes. And of course, there will be an obligation to provide this information or serve this information, ideally at the point at which you are collecting personal data. So for example, if you're asking someone to complete an online form to subscribe to direct marketing activities and to provide their name and email address in that form, you ought to be serving or including a link to your privacy notice at that point. So the second key consideration is, of course, lawful basis. Now, again, you'll remember from earlier modules that whenever you're processing personal data, you need to have a lawful basis to do so. Now, in the context of direct marketing activities, the most relevant legal basis that you'll be looking at will either be legitimate interests or consent, and we'll come on to consider that in a little bit more detail in the upcoming slides. The third key consideration is that of accountability. Again, you may recall from earlier modules, but recapping here again, that one of the key requirements under the GDPR is this concept of accountability. So being able to demonstrate that how you are complying with your obligations under the GDPR is sort of an overriding principle that underpins all of those obligations. So in the context of your direct marketing activities, and particularly if you're relying on consent, you'll need to be keeping records of those consents. So you'll need to be able to demonstrate that you've got valid consent by demonstrating when you obtained consent, who consented, what they consented to, and when they consented. So that's a key point for sort of reliance on consent, is being able to demonstrate the validity of those consents. And finally, you will remember that the GDPR provides data subjects with a whole bunch or a whole suite of rights. Now, we refer to these as data subject rights. But a key right in the context of direct marketing is the right to object to direct marketing. Now, it's important to note that the right to object to direct marketing is an absolute right, which means that once someone exercises their right to object to direct marketing, the controller has to comply with it. So there's no ability to argue that you have overriding interests to continue to market to someone once an individual has exercised that right to object. So just to build on the concept of consent, as I touched on in the last slide, if you are relying on consent as your lawful basis to process personal data for direct marketing purposes, of course, the GDPR requires a specific standard of consent. Just by way of reminder, that is that consent must be freely given, it must be specific, it must be informed, and it must be indicated by a clear affirmative action on the part of the individual. So just keep in mind that the likes of pre-ticked boxes or implied consent won't be sufficient. So it's certainly worth keeping these requirements in mind when you are designing your direct marketing consents. So as well as the GDPR, you'll also need to comply with the provisions of the e-privacy directive in respect of any electronic direct marketing. So we'll come on to explain what's meant by and what's captured by this concept of electronic direct marketing in the next slide. But in the meantime, just to give you a bit of context to the kind of differences between a directive and a regulation. So we've been talking about the GDPR and our obligations under the GDPR so far, which is the General Data Protection Regulation. Now, as a regulation, the GDPR has direct effect in all EU member states. By contrast, directives such as the e-privacy directive simply set out broad rules or principles that each EU member state has to implement or transpose into their local laws. So what that means is that the rules relating to electronic direct marketing under the e-privacy directive does differ slightly across different EU member states. There's a little bit of fragmentation in the way that different member states have implemented the directive. Now, I should mention at this point that the EU is currently in the process of replacing or looking to replace the e-privacy directive with a new e-privacy regulation. But unfortunately, the e-privacy regulation was actually intended to come into effect around the same time as the GDPR, but it's still yet to be finalised and agreed by the European legislators. So we're still some way off of seeing a final form e-privacy regulation. And even once it is finalised, of course, there'll be a period of implementation, which could be anywhere between 1 year to 2 years. So yeah, something coming in the pipeline, but not just quite yet.
In this session, we'll focus on the rules on electronic marketing. We should note here that the e-Privacy Directive governs electronic marketing only. In particular, marketing sent by email, text, fax, and automated calling machines. Non-electronic methods of marketing, for example, via post and phone calls, are not covered by the directive. Other types of communication will be governed by different rules. There are also different rules that apply when you are contacting a business rather than an individual. These are often less strict and can vary across the EU. Under the e-Privacy Directive, the default position is that when you are sending electronic direct marketing to individuals, you have to first obtain their consent. There is an exemption to this, known as the soft opt-in exemption, which we will explore in more detail in the following slide. This default position of prior consent only applies to business-to-consumer or B2C electronic marketing. As mentioned, the rules that apply when you send B2B or business-to-business electronic marketing differ more widely across member states, depending on the local laws that are applied in each country. Some countries permit B2B marketing on an opt-out basis, whilst others permit it on an opt-in basis unless the soft opt-in exemption applies. If you'd like to compare the position across different member states in more detail, we've included a link in this slide to a very helpful resource that Phil Fisher has prepared. This shows the various local law consent requirements for sending both B2B and B2C electronic marketing across Europe, both on a first-party and a third-party basis. I mentioned the soft opt-in exemption on the previous slide. If this exemption applies, you don't have to obtain an individual's prior consent before sending them electronic marketing. As a reminder, electronic marketing includes marketing sent via email, text, and video or picture messages. The soft opt-in exemption will apply where you have satisfied all of the conditions set out on this slide. First, you must have obtained that recipient's contact details in the course of the sale or negotiations for the sale of a product or service to that recipient. For example, if you collected an individual's name and email address when they made the purchase with you. Now, it's important to note that this exemption will only apply in the context of the sale or negotiations relating to similar products and services that you intend to market. So, if you've obtained the individual's contact details when selling them a new pair of socks, you can rely on this exemption to send them marketing about socks or other items of clothing, although just how similar the products need to be will vary across the EU. However, you can't then use this exemption to send them marketing about wine, for example. Crucially, you must also give the recipient the option of saying no to or unsubscribing from receiving marketing communications from you. This has to happen both at the point you collect their details and in all subsequent communications. The concept of the sale or negotiations has been interpreted more broadly in some EU member states than in others. Some countries will require an actual sale that takes place for this exemption to apply, whereas others, including the UK, interpret negotiations for sale more liberally. For example, assuming that this will be satisfied if an individual adds goods to their baskets or asks the organisation for more details about a particular product or service. This is because those actions involve the consumer actively expressing an interest in buying the organisation's products or services. Where you rely on the soft opt-in exemption to send marketing communications, your legal basis for the data processing under the GDPR will be legitimate interests rather than consent. Remember to document your legal basis of processing in order to comply with the accountability principle.
So we've very much been focusing on the direct marketing rules as they apply at an EU level, but we thought it might be helpful to just give a quick snapshot of a UK perspective, a snapshot of the different rules and the different types of direct marketing from a UK perspective, looking at this through a B2C lens, so direct marketing to individuals as opposed to businesses. So as you can see, we've included 5 different types of marketing mediums. And the first 3, emails, automated calls, and SMS, will constitute electronic direct marketing and so will be governed by the e-Privacy Directive rules. So as we've just covered in the preceding slides, where you're carrying out electronic direct marketing, you either need to get consent unless you can rely on the soft opt-in exemption where it's available to you. Now, the rules relating to live calls and postal marketing are not quite as strict. So as you can see, you can carry out telephone direct marketing calls without consent, provided that you give individuals the right to opt out. And then very importantly is that in the UK, there is a requirement, a legal requirement, to actually screen your telephone marketing databases against the Telephone Preference Service, or the TPS. So anyone that's registered with the TPS, you are not permitted to market to. So you have to sort of opt them out of your marketing database if they're already included. So you actually are under an obligation to screen against the TPS. In relation to postal marketing, again, you don't need prior consent. But you do need to offer individuals the right to opt out. And it's also, although it's not a legal requirement, it's also good practice, best practice to screen against the MPS, so the Mail Preference Service. Again, it's not a legal requirement, but it is good practice because obviously if individuals have actually registered for the Mail Preference Service and then start to receive postal direct marketing from you, they might just get a little bit grumpy with you or want to opt out anyway. So that's the position, broadly, a snapshot of the B2C direct marketing rules in the UK. But again, the rules for sending marketing in other EU member states may differ slightly. So this slide is a word of caution about third-party marketing. So in terms of what third-party marketing is, if a third party is collecting personal data on your behalf that you then subsequently intend to market to, that will constitute third-party marketing. So if you are buying marketing lists or lists of personal data of individuals who you intend to market to, if you're buying those lists from a third party, you'll need to take extra care to ensure that you're complying with the applicable requirements. And that's because you need to be satisfied that the third party you're purchasing these lists from has obtained the information fairly and lawfully for the purposes of the GDPR. So, for example, they've provided the relevant information requirements to individuals to inform them of their intention to share data with a third party. And you'll need to ensure that they've also obtained a valid consent on your behalf. Now, in particular for these purposes, this will require that you, as the eventual sender of the direct marketing, are named as the party that the individual is consenting to receive direct marketing from. It won't be sufficient that the third party merely collects, say, sort of general consent from that individual to its sharing of data with third parties generally for direct marketing purposes. And that's because that won't satisfy the requirements of specific informed consent under the GDPR. The other point to mention is that the soft opt-in exemption isn't available for third-party marketing. So again, that means that you can't rely on the soft opt-in arguments that your third party might have. You'll have to rely on consent. So when you're looking to buy a database or looking to purchase a marketing list from a third party, what this means is that you should really be carrying out appropriate checks and due diligence to make sure that the consent that that third party has obtained is suitable for your purposes and can be relied on for your direct marketing activities. And typically, it's very sensible to ensure that those checks and due diligence exercises are backed up with contractual assurances from those third parties.
In this session, we have covered the laws primarily governing the area of direct marketing. However, you should note that there may also be other local laws and recommendations that apply to you. This will depend upon the type of marketing that you are looking to send and where you are planning to send it. For example, in the UK, the Privacy and Electronic Communication Regulations, or PECR, implements the e-privacy directive into local law. The Communications Act 2003 covers the improper use of a public electronic communications network, including making silent or abandoned calls. Also, the Direct Marketing Association publishes the Direct Marketing Code of Practice, setting standards of ethical conduct and best practice in direct marketing. Finally, the Consumer Protections from Unfair Trading Regulation 2008 prohibit a number of unfair, misleading or aggressive marketing practices, including marketing persistent and unwanted solicitations by telephone, fax, email and other remote media. We have now come to the end of this session. Thank you for watching. By now, you should be able to better explain the meaning of direct marketing, understand which laws primarily govern direct marketing, and recognize how you can lawfully carry out direct marketing activities.